All right, class, settle in, settle in. Welcome. Today, we are cracking open the Constitution to look at one of its most powerful and, I think, most fascinating provisions. We're going to talk about how a country legally grows.
So just think about that for a second. How does a country's map actually change? Now, I'm not talking about just shuffling the borders between existing states. No, I'm talking about the really big move, adding entirely new territory to the country. This isn't just about drawing lines. It's about constitutional law, and it all boils down to one incredibly powerful article.
So here's our game plan for today. We'll start with the big idea. Then we'll decode the actual legal text. We'll clear up a super common point of confusion, look at a classic real-world example, see how the courts have handled it, and then I'll give you the final takeaways you need to know. Sound good? Let's jump in.
Okay, first things first. Any constitution worth its salt has to have a plan for growth, right? Whether a country acquires new land through a treaty or some other kind of integration, there has to be a legal framework for it. It's a fundamental part of being a sovereign nation.
And in India, that specific tool is Article 2. You can think of it as the constitutional engine that gives Parliament the authority to actually expand the Union of India. It's the legal front door for any new territory hoping to join the country.
All right, let's put the text itself under the microscope. To really get a handle on this kind of power, you have to look at the exact words the framers chose. Every word matters. And here it is. Parliament may by law admit into the Union or establish new states on such terms and conditions as it thinks fit. Now, right away, two key actions should jump out at you: admit and establish. And pay very close attention to that last little bit, on such terms and conditions as it thinks fit. Whoa, that's a lot of power. So what's the difference between admit and establish? This isn't just about semantics. It's a crucial legal distinction. Admit is for when you're bringing in a political entity that already exists. Think of it like inviting an established neighbor to join your club. The classic example here, the one you absolutely have to remember, is Sikkim. On the flip side, establish is for creating a brand new state from scratch, on territory that wasn't organized that way before.
So, what is the nature of this power? Well, first, it belongs exclusively to Parliament. And second, here's a key legal term for you, it's a plenary power. Plenary. That means it's absolute, it's complete, it's unqualified. Parliament gets to decide all the terms. And here's the real kicker. A law made under Article 2 is not considered a constitutional amendment. That means it only needs a simple majority in Parliament to pass. That's a much lower bar.
Okay, lean in for this next part, because this is without a doubt the number one thing students get confused about. It's a classic exam question, so you'll want to pay close attention. We're talking about the difference between Article 2 and its next-door neighbor, Article 3. If you remember just one thing from today, let it be this. Article 2 is for what's outside. It's for bringing external territories into India. Article 3, on the other hand, is for what's already inside. It deals with reorganizing the states that are already part of the country. So one is about adding a whole new page to the atlas. The other is just about redrawing the lines on the pages you already have. And this chart just lays it out so clearly. Look at Article 2. The scope is to admit or establish, the territory type is external, and the procedure is a simple majority. Now look at Article 3. Scope is to reorganize or rename, territory is internal, and it's also a simple majority. You can see how they're distinct tools for different jobs. And notice they're both totally separate from the heavy-duty process of constitutional amendment under Article 368.
Okay, that's enough theory. Let's get into how this actually works in the real world. And believe me, there is no better example of Article 2 in action than the story of how Sikkim became a state of India.
Now, of course, Sikkim wasn't the only one. After independence, India integrated other territories too, like Goa and Pondicherry. But Sikkim's case is it's special. It perfectly illustrates that admit power we were just talking about. And here's why it's the perfect example. Sikkim was already an existing political entity. It was a kingdom, so Parliament couldn't establish it, right? It had to admit it into the Union. This makes it the absolute textbook case study for this specific function of Article 2.
And the whole thing was made official with the 36th Constitutional Amendment Act back in 1975. That's the piece of legislation you'll want to cite. It's what officially made Sikkim the 22nd state of the Indian Union.
Now, whenever you have a power this big and broad, you just know it's going to be challenged in court. It's inevitable. So let's take a look at what the Supreme Court had to say when this power was put to the test.
So our first case is Mangal Singh versus the Union of India. Here's the short version. A union of former princely states had merged with Punjab. Later on, Parliament tried to change the terms of that merger, and the original parties challenged it.
This raised a massive legal question for the court. Is Parliament's power under Article 2 so absolute that it can just go back and rewrite a deal it already made? Can it change the conditions of a merger after the fact?
And the Supreme Court's answer was a thunderclap. In its ruling, the court said the power of Parliament is wide and plenary, and then it dropped this word: unfettered. Unfettered! That judgment basically cemented the idea that Parliament's authority here is total and it isn't limited by previous agreements. But hold on. If the power is unfettered, does that mean it can just trample all over people's rights? Well, that leads us right into our second case, Satpal versus the state of Punjab. This one was all about the rights of citizens after the reorganization of Punjab and Chandigarh. So the issue here was, well, fundamental. When Parliament redraws the map, can it also shrink the fundamental rights of the people who live there? Does a change in your state's borders mean a change in your basic rights as a citizen?
And on this, the Supreme Court drew a very clear line in the sand. The answer was a definitive no. It held that citizens retain all of their constitutional rights. Reorganizing territory does not and cannot affect fundamental rights. This ruling is so important because it acts as a crucial guardrail on that unfettered power.
All right, let's wrap this up and bring it all home. We've gone through the text, the key differences, a major case study, and the court's interpretations. So here's what you absolutely must take away from today.
Here's your checklist. 1. Article 2 is for outside, Article 3 is for inside. That is the golden rule. 2. Remember those magic words from the court? Parliament's power is plenary and unfettered. 3. It only takes a simple majority. 4. Your go-to example is always Sikkim, 1975. And 5. The most important check on this power, it cannot be used to take away a citizen's fundamental rights.
And I'll leave you with a final question to chew on. The Supreme Court called this power plenary and unfettered, but it also put up a hard stop when it comes to fundamental rights. So what are the real limits on this power? Not just in the letter of the law, but within the very structure of a democracy. That's something to think about. Class dismissed.